Get ready. 3 seconds. 2 seconds. Start. The appellant herein stands convicted for the offense of murder and also for causing disappearance of the evidence of the offense. White impugned judgment dated 27/5/2009 passed by the learned additional session judge in session case number 57 of 2008. After convicting the appellant for the offense of murder under section 302 IPC, he has been sentenced to undergo imprisonment for life and also to pay fine of rupees 5,000 with default, sentenced for further rigorous imprisonment for 1 year under section 302 IPC. At the same time, the appellant has been sentenced to undergo rigorous imprisonment for 7 years with fine of rupees 1,000 and default, sentence for further rigorous imprisonment for 6 months under section 201 IPC. Being aggrieved with the conviction, the accused has preferred this appeal from jail. Heard learned amicus curiae for the appellant and learned additional public prosecutor for the state, also gone through the impugned judgment and the prosecution evidence tendered in the trial court. The defense case was of total denial and no evidence in defense was tendered. Altogether, 9 witnesses were examined by the prosecution. PW1 is the autopsy doctor and PW9 is the IO. PW8 is the brother of the deceased, and on being learned about the offense of murder of his sister from the village headman, he lodged the FIR. However, PW8 has not spoken about any incriminating evidence against the appellant. PW7 is the brother of the accused. When he came to know about the murder of the deceased, he visited the house of the village headman and found the accused kept confined by villagers. He was reported by the Gauhati that the accused had committed murder. PWs 2, 3, 4, and 5 are the co-villagers of the accused and the deceased. All these witnesses have deposed in one voice that at about midnight on the relevant day, they heard shouting of the accused. Accordingly, each of them came out on the road and heard the accused shouting that he had committed the murder of with a dagger, suspecting her to be a witch. Thereafter, the accused was kept confined in the house of the Gauhati, and on being inquired, the accused further disclosed that the dead body was thrown into the river and the dagger was thrown in a nearby jungle. All the aforesaid witnesses have also spoken about the recovery of dead body from the river as well as the recovery of a dagger from the jungle at the instance of the accused. Only PW4 did not accompany the accused, and the police in jungle wherefrom the dagger was recovered. However, he knew that the dagger was recovered at the instance of the accused. Be that as it may, the remaining witnesses have spoken about the recovery of the weapon on being pointed out by the accused. PW6 saw the dead body in the police station and found injuries on her chest. As noted earlier, the accused did not take any defense plea either in the cross-examination of the prosecution witnesses or in his statement under section 313 CRPC. At the same time, we do not find any material to disbelieve the testimony of the prosecution witnesses implicating the appellant in the offense of murder. In our considered opinion, extrajudicial confession is corroborated by recovery of the dead body and weapon at the instance of the accused. Stop.